with the civil side of litigation because my main area of expertise is in the criminal law. But what we have noticed in Hong Kong in terms of trend is that there's a coming back to court litigation away from arbitration, simply because arbitration now has become more expensive and cumbersome. And so people are finding that even though they've had difficulties with court litigation in the past, it does provide a degree of certainty that they require, but more importantly, enforceability. And I think enforceability is probably the key consideration. So we've noticed that particular trend. It's mainly anecdotal. I don't have facts and figures, but we've seen that. We've also seen a huge rise in mediation, and mediation is now becoming the hallmark in a lot of disputes. It'd be surprising where you actually find provisions for mediation in relation to the typical areas like family law, and also when you're dealing with regulatory bodies now, they are starting a process of mediation. Now, just dealing very quickly with the criminal law, when you're dealing with public regulators, what I've noticed in terms of a trend, and I'm talking about my experience as the Director of Public Prosecutions in Hong Kong and as a white-collar crime specialist when I was practicing as a barrister, and that you're seeing now the emphasis being placed on the stakeholders in terms of the corporations, the individuals that have a responsibility, or the financial institutions or the banks, etc., to comply with certain requirements. And that would be to report, to disclose, and they are subject to criminal sanctions. And that's the new initiative. And so there's a lot at stake. And so there's a lot of pressure on individuals and entities to comply with the statutory and regulatory requirements. Otherwise, you could find yourself being prosecuted. And so what is happening is because law enforcement basically failed. It was in essence organised crime versus disorganised law enforcement because of the fragmentation of law enforcement, and there wasn't any cohesion or coordination. So they've put the burden on the individual or the entity to be the eyes and ears of the police. So in that sense, we're seeing a paradigm shift, and it's quite significant, placing more obligation, legal obligations, on individuals and entities. We've also seen other initiatives where you are obliged to do record keeping, customer due diligence, and making it a legal requirement that you do so, and failure to do so, non-compliance, can result in serious penalties. Also, we're seeing as a means of a defence, if you look at the UK Bribery Act of 2014, there they've got a defence that if you, as an entity, because it relates to corporations as well as individuals, but if the company has put in measures to deal with corruption, it can be used as a defence if the company gets prosecuted. So you can rely on that. And also they have now, we haven't seen this in Hong Kong, but UK, I think Australia, France and other countries, the deferred prosecution agreements, where the interesting experience has been in the UK. It's an agreement with a corporation. It can't be with an individual to suspend prosecution and then subject to terms and conditions, and it's sanctioned by the court. So not subject to the individuals. The individuals then get prosecuted. And so far, most of the cases that they have prosecuted against individuals, they've been acquitted, even though the company has admitted criminal liability. So that is also a trend, deferred prosecution agreements.